To my right is an email that was sent by the victim's lawyers to the DOJ. It was a list of names not to redact, a list of names not to release. What did the DOJ do with this email? They released this email in the document production. Literally the worst thing you could do to the survivors, you did. And they're getting phone calls. A lot of these people didn't want to be known. And we know you touched the document because you redacted one name and you redacted the lawyer's name, but you left the survivor's name there. The next document I want to show you, that was in the title, the victim's survivors' names, all right? The title of this one is Child Sex Trafficking, Co-Conspirators, fully redacted. And by the way,
a congressional hearing turned into a fiery confrontation when lawmakers accused the Justice Department of failing to properly handle Epstein-related documents, including allegations that survivor information was exposed while other material remained heavily redacted. As officials defended their actions, the exchange became a larger fight over transparency, accountability, and whether the public is getting the full truth.
Is recognized for 5
May I
minutes.
respond very briefly to her statement?
Well, I think we can do that
Okay.
probably on
Next.
one of our members' time.
Okay, thank you. I don't want that to get away. Thank you.
Yep.
thank you, Mr. Chairman. Behind me, I have 3 documents from the DOJ production that are emblematic of the massive failure of the DOJ to comply with the Epstein Files Transparency Act. To my right is an email that was sent by the victim's lawyers to the DOJ. It was a list of names not to redact, a list of names not to release. What did the DOJ do with this email? They released this email in the document production. Literally the worst thing you could do to the survivors, you did. And they're getting phone calls. A lot of these people didn't want to be known. And we know you touched the document because you redacted one name and you redacted the lawyer's name, but you left the survivor's name there. The next document I want to show you, that was in the title, the victim's survivors' names, all right? The title of this one is Child Sex Trafficking, Co-Conspirators, fully redacted. And by the way, I'm going to unredact them here. Les Wexner is in this. Now, your your deputy attorney general said, oh, well, he appears hundreds of times in the files. But he doesn't appear in this file until I forced you to release it, where he's listed as a co-conspirator, not to tax evasion, but to child sex trafficking, not to prostitution, not to money laundering, child sex trafficking. And then finally, what we have here is the third exhibit that I have is emblematic of the FD 302 release. These are the documents that we need that you're holding on to and over-redacting because they have the names of the men who are implicated. How do we know? Because the survivors gave testimony to the FBI, and it's in there. And what happens when you go to the portal at the DOJ to look at what's behind this redaction? Another redaction. So we can't even see them. And then there's some of these files you've pulled down from the website that we will never see because we can't search the redactions. So I have several questions for you. Who's responsible? Are you able to track who in your organization made this massive failure and released the victims' names? Are you able to track who it was that obscured Les Wexner's name as a co-conspirator in an FBI document? Do you have that kind of accountability?
I believe Wexner's name was listed more than 4,000 times.
Yeah, I already told you that. This is where he's listed as a co-conspirator.
Can I finish my answer? Come on, let me finish my answer. We corrected that within 40 minutes. He was already, you're acting like everybody's trying to cover up Wexner's name.
Reclaiming my time.
I'm going to answer this question.
Reclaiming my time.
Mr. Chairman. This isn't how this works.
Can I have my time back? Mr. Chairman.
The gentlelady can give her answer. The time belongs to the gentleman from Kentucky.
All right, I'm reclaiming my time.
Can I give my answer?
So
Yes.
I'm going to put the language of the bill up on the screen.
Chairman, may I give my answer on that? It's a political joke, and I need to give my answer on that.
We'll let the Attorney General respond, and then the gentleman can move to his next question.
It's my time.
Within 40 minutes, you asked me a question. Within 40 minutes, Wexner's name was added back.
Within 40 minutes of me catching you red-handed.
There was one redaction out
Where
of
he's
over
listed as a co-conspirator.
4,700,
Okay.
and we invited
what?
you
Show the
in.
video.
This
Show
guy
the-
has Trump derangement syndrome. He needs to get, you're a failed
He won.
politician.
Did
Gentlemen,
Epstein
you need to
I
get
want
on
you to
these
watch the video.
matters.
Mr. Chairman, please restore his time and remind the witness of the
himself,
rules here.
there is
Time.
no credible information. None. If there were, I would bring the case yesterday that he trafficked to other individuals.
Is that your position as well?
My position is any victim who comes forward, of course, we would love to hear from them. 1-800-CALL-FBI. Did you ask Merrick Garland that the last 4 years? Did you talk about Epstein?
I am
at
reclaiming
all
my
the
time.
last
I'm
4
glad you're
years?
asking about Merrick Garland.
You don't get to reclaim
because
time
this
when
is
you don't-
bigger than
when you can't-
Watergate.
when I don't answer a question the way you
goes
want.
over 4 administrations. You don't have to go back to Biden. Let's go back to Obama. Let's go back to George Bush. This cover-up spans decades, and you are responsible for this portion of it.
And that's
now,
where the
I want to
most
know at
transparent-
what point did the FBI and the DOJ decide that Lex Wessner was not a co-conspirator? Because our Epstein Files Transparency Act requires you, please put it
Time is
back on the
up.
screen, please, to release the internal decision about whether to prosecute him or not, and it's not in the files, and it's not in the files for any of these other men.
Time of the gentleman has
Which,
expired.
may she answer?
And he's a hypocrite because he voted against the ban that we were talking about on deep fake AI porn. Only 2 people voted against it, and you were one of them, hypocrite.
The gentleman's time has expired. She didn't answer the question.
Mr.
Yeah,
Chairman,
I would,
point of
Mr.
order.
Chairman, could she answer the question?
Chairman, I was wondering,
The gentlelady's allowed, the Attorney General's allowed to respond the way she wants to respond to any member's questions, Republican, Democrat.
All right, I have unanimous consent request.
Gentleman's recognized for a UC.
All right, this is an example. I'm submitting these 302 forms that are entirely redacted, even when you go to look at
Without
them.
objection.
I'm submitting a witness statement that implicates Les Wexner.
Without objection.
I'm submitting an article from the New York Times that the DOJ released nude photos and
Without objection.
identifiable pictures of the victims. I'm submitting a letter from A.G. Bondi to Kash Patel, imploring him to quit keeping the files when you found out that they were keeping files from you, because
Without
they're still
objection.
redacting files that you.
Chairman, are we going to
Without
recess for votes?
Yes, we are.
I'm submitting for unanimous consent a document of 17 individuals who've resigned because of the Epstein files.
Without objection. Just want to check on how much time we have left in votes, but one thing I've learned here of late that they'll wait on us. How much time do we have? Oh, they just called. Okay. The chair now recognizes.
This exchange quickly became one of the most intense moments of the hearing as lawmakers confronted the Justice Department over the handling of Epstein-related documents and whether the department had properly followed transparency requirements. The questioning began with a series of documents displayed as examples of what the lawmaker described as major failures in the DOJ's release process. The first issue raised involved an email from attorneys representing survivors. The lawmaker argued that the email contained sensitive information and instructions regarding survivor identities, yet the document itself was released publicly. The concern raised was serious. When victims of crimes provide information to authorities, they expect those institutions to protect their privacy and handle sensitive records carefully. The lawmaker argued that releasing information connected to survivors could cause additional harm to people who have already experienced trauma. The discussion then moved to heavily redacted documents involving individuals connected to the Epstein investigation. The lawmaker argued that some names and details appeared to have been removed from documents even when the public interest in understanding the records remained high. This led to the central question of the exchange. Who made these decisions, and who is accountable for them? The lawmaker repeatedly pressed the DOJ official on whether the department could identify who approved the redactions, who reviewed the documents, and whether there was a system in place to prevent mistakes. That question goes to the heart of government transparency. When agencies release large amounts of information, especially in high-profile criminal investigations, the process involves balancing multiple responsibilities. Protecting victims, protecting ongoing investigations, following court rules, and providing the public with meaningful access to information. The disagreement in this hearing centered on whether the DOJ had found the right balance. The lawmaker argued that too much information was being hidden and that excessive redactions prevented Congress and the public from understanding what happened. The DOJ defended its actions by arguing that certain information must be protected, particularly information involving victims and legally protected material. The exchange became even more heated when the discussion turned to Leslie Wexner, a longtime associate of Jeffrey Epstein whose name appeared in the documents being discussed. The lawmaker argued that documents contained references that deserved further scrutiny and questioned why certain information was not visible earlier. The DOJ official responded that the name had appeared thousands of times in released materials and rejected the suggestion that there was an effort to hide information. This became a broader argument about interpretation. One side argued that missing or redacted information creates suspicion and requires further explanation. The other argued that accusations of a cover-up ignore the legal requirements agencies must follow when releasing sensitive records. The hearing then moved into a larger question, whether the Justice Department has done enough to pursue accountability related to Epstein's crimes. The lawmaker argued that the public still wants answers about whether additional individuals could have been held responsible and whether previous decisions deserve more scrutiny. The DOJ responded that prosecutors can only pursue cases where evidence meets legal standards and that anyone with credible evidence of criminal activity should come forward. This is an important distinction. Public pressure can demand transparency, but criminal prosecutions require evidence that meets the standards of the justice system. The final part of the exchange focused on the relationship between political leadership and the Justice Department. The lawmaker questioned whether DOJ officials were prioritizing loyalty to political figures over accountability for victims. The DOJ official rejected that idea and stated that protecting victims and pursuing criminals remained the department's responsibility. By the end of the confrontation, the disagreement was clear. Lawmakers argued that the Epstein files process showed a lack of transparency and accountability. The Justice Department argued that it was following legal requirements while protecting sensitive information. But underneath the heated exchange was a much bigger issue. How does the government prove to the public that powerful individuals are not receiving special treatment? That question is why cases like this continue to receive intense attention. For survivors, transparency and accountability are not just political issues. They are about whether institutions listened, whether investigations were taken seriously, and whether justice applies equally regardless of a person's wealth or influence. This hearing showed that the debate over Epstein-related records is not only about documents. It is about public trust in the institutions responsible for protecting victims and enforcing the law. Subscribe to Capital Breakdown HQ for more congressional hearing breakdowns, government oversight, and accountability-focused political analysis.